Well. Excellencies, distinguished guests, dear colleagues, ladies and gentlemen, good morning, good afternoon. On behalf of Parliamentarians for Global Action, it is my distinct pleasure to welcome you to this Assembly of States Parties side event titled When Vetoes Prevent Accountability, a critical examination of blocking ICC referrals. Thank you all for being a part of this important conversation on the use or threat of use of the veto power in the face of mass atrocities. I wish to extend sincere thanks to the distinguished panelists and to Canada, the Kingdom of the Netherlands, the Permanent Mission of Costa Rica to the United Nations, and the Permanent Mission of Sierra Leone to the UN for sponsoring this event. This side event considers the problem of a permanent member of the UN Security Council blocking a referral to the International Criminal Court in a situation when the Security Council would otherwise be willing to act in the face of core international crimes. The discussions will include the extent to which blocking accountability measures up to states' obligations under international law and the United Nations Charter. Additionally, panelists will consider the ramifications of impunity, since vetoes in the face of atrocity crimes convey the message to would-be perpetrators that they are unlikely to face systematic accountability. Moreover, vetoes enabling cycles of violence to continue also likely mean the continuation of core international crimes. The panelists will also discuss the silencing effect of the threat of the veto and the veto itself when certain referrals are never even proposed because it is anticipated they will be vetoed by one of the Permanent Security Council members. This is becoming increasingly unacceptable to much of the international community, which can be seen in the widespread support for various voluntary veto restraint and similar initiatives at the United Nations. Similarly, the book of Professor Trahan on existing legal limits to Security Council veto power in the face of atrocity crimes offer a comprehensive analysis of the topic and compelling arguments that Parliamentarians for Global Action strongly support, including that while genocide, crimes against humanity, and war crimes are taking place, the UN Security Council permanent members cannot exercise their veto power outside of the legal limits imposed by jus cogens, by the United Nations Charter's purposes and principles, and by international instruments ratified by permanent members like the Genocide Convention. I would like to kindly ask you, before we start, to mute your microphone if you're not speaking, to help keep background noise to a minimum. In the interest of time, we kindly ask participants to also keep their questions and comments short in the Q&A section. And please note that this event is being recorded. So we now turn to the distinguished panel, and the panelists are absolutely amazing. Before we will start with Ambassador Correll, who is a prominent lawyer and diplomat. Between March 1994 and March 2004, he was Undersecretary General for Legal Affairs and the Legal Counsel of the United Nations. In this capacity, he was head of the Office of Legal Affairs in the United Nations Secretariat. Please, Ambassador Correll, we hand you the floor. Thank you.
Thank you very much. I'm very grateful for being invited to this panel where we are going to discuss Professor Trahan's book, which is very important indeed. But my main concern here first is actually the Security Council and the manner in which the Council operates, not only with respect to the veto, but at large. And I'm disappointed because I don't see the statesmanship that we should expect from the Council today. Let us just look at the world today and see all the threats against peace and security we have. We have the climate change, we have the growing world population, we have desertification, we have ices melting in the Arctic and Antarctica and so forth. There are so many elements that will be threatening peace and security. And therefore, the rule of law is extremely important here. And the Council simply has to discuss this. There's a lot of discussion in the United Nations about reforming the Security Council, but almost all discussion focuses on enlarging the Council. But that's a problem because it will not solve the real issue with the Council. Already 15 members is a lot for an executive organ, which the Council is. And if they enlarge the Council, it will not solve the real problem, namely the manner in which the 5 permanent members sometimes behave. And this is why it's so important that the 5 permanent members sit down and discuss the future and how they should behave. And if we look at the young generation now, we see the criticism voiced here, not least in relation to the climate issue and so forth, how important it is that we really look to the future and see what can be done here. And therefore, one of the most important things is the rule of law and the way in which the Council can assist in establishing a proper order in the world. And if we look at the Council and criminal law, it was a very positive development during the 90s when the Council was able to establish the Yugoslav Tribunal and then the Rwanda Tribunal. And then I had the privilege of negotiating the agreement between the United Nations and Sierra Leone for the special court there, and then with Cambodia for the special chambers in Cambodia. And of course, Richard Goldstone here is extraordinary because he was the first real prosecutor in the Yugoslav Tribunal. And I think it's very important to realize that if the issue of establishing a criminal court is discussed today in the Security Council, they don't have to establish a new court. They can actually use this standing international criminal court that was negotiated in Rome in 1998. And I had the privilege of being Secretary General Kofi Annan's personal representative at that conference. And when that statute entered into force in 2002, the Security Council has the right to ask the prosecutor of the court to address a situation where crimes are being committed. And this means that it is not necessary to establish new courts of the kind that the Yugoslav and the Rwanda Tribunal represent, but they can ask the ICC to ask the prosecutor in the ICC to look at the situation. And this is why it is so important when we read Professor Trahan's book, when she discusses the use of the veto, that if a member of the Security Council vetoes a resolution where a referral to the ICC is contemplated, this stops the prosecutor from proceeding. And the question is then, is this legal? So for me, it is extremely important that when the issue of establishing a contact between the Security Council and the International Criminal Court is discussed in the Council, that it is not vetoed if the whole idea is to prevent crimes against humanity, war crimes, or genocide being committed. So for me, this is a very important topic, but I will revert to this later during the discussion, but I just wanted to make that point that Professor Trahan's book addresses an issue which is an element among more elements that we have to look at when we discuss the manner in which the Security Council, the most powerful organ of the United Nations, behave. Thank you.
Thank you so much, Ambassador Correll. I would like to now introduce Justice Goldstone, who is the Chief Prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda from August 1994 to September 1996. Justice Goldstone recently chaired, as you all know, the Independent Expert Review Group established in December 2019 by the Assembly of States Parties to review the International Criminal Court and the Rome Statute system. Justice Goldstone, I think that we all agree that one measure of effectiveness of international criminal justice is whether it is able to deter the commission of core international crimes. In a situation where the ICC does not otherwise have jurisdiction, What is your sense of the difference a Security Council referral to the ICC makes versus waiting for individual perpetrators to travel to countries that might exercise universal jurisdiction?
Well, thank you very much indeed for the question, and I'm also very grateful for the invitation to participate in this important discussion. Before answering your question, might I just say that I agree entirely with everything that has just been stated by Ambassador Collateral, and I would add really what underlies the whole discussion is really the rule of law. It's the rule of law in the international community, which was stressed by the late Secretary General Kofi Annan many years ago, that the rule of law in the international community is no less important than the rule of law in a domestic system. And unfortunately, in too many places, the rule of law today is being downgraded, if not neglected. But to answer your question, let me begin on a negative note. The whole question of deterrence of justice is very difficult to establish. It's difficult always to prove a negative. What would be the position if there wasn't criminal justice, either domestically or internationally? What effect would that have on the crime rate? Let me begin on a negative note. The threat of justice is not always a deterrent. The genocide committed in 1995 in Srebrenica was orchestrated by Radovan Karadzic and Ratko Mladic just a few months after they were both indicted by the Yugoslavia Tribunal for war crimes. That was a personal disappointment to me. It probably reflected their own understandable optimism of always being protected by their own governments from having to appear in The Hague. Having said that, on the positive side, it's undoubtedly correct that countries with an efficient criminal justice system have a lower crime rate than those with inefficient criminal justice systems. At least some would-be perpetrators are deterred from committing crimes if they fear apprehension and punishment. In Syria, President Assad can commit heinous war crimes, secure in the knowledge that the Russian veto will protect him from any international investigation, and especially by the ICC. We will shortly be discussing further what that kind of veto, what is really, as Professor Trahan demonstrates very clearly in her book, it is an unlawful use of the veto. An investigation by the Office of the Prosecutor of the ICC always shines a global spotlight on the activities of alleged criminal leaders. That will doubtless affect their behavior. Whether for better or for worse, their behavior will be affected. Relying on domestic systems to go after war criminals using universal jurisdiction has one important limitation. The crimes that can be prosecuted will depend entirely on the individual apprehended by the domestic authorities. If he or she is a low-level criminal, then of course it's those lower-level crimes that will fall within the jurisdiction of a domestic court using universal jurisdiction. In the case of an ICC investigation, on the other hand, the prosecutor is able to go after those most responsible, those most guilty. Where an international criminal tribunal has jurisdiction, the prosecutor is able to look at the whole situation and investigate the most serious crimes committed and go as far up the ladder of responsibility as possible and to indict the most guilty. That is usually those who planned the commission of the war crimes that were committed. Of course, the seriousness of the crime speaks for itself. That process is not open in the case where a domestic court relies on universal jurisdiction. We will come back later to other aspects of the use of the veto.
Thank you so much, Justice Goldstone. Professor Trahan, we're going to go back to you. You are, as everybody knows, you're a clinical professor at NYU's Center for Global Affairs and director of the Concentration in International Law and Human Rights. You are a prolific scholar, having published scores of law reviews and book chapters, including your latest book on existing legal limits to Security Council veto power in the face of atrocity crimes, published in 2020. I understand that your book looks at the legality of vetoes while there are ongoing genocide, crimes against humanity, and war crimes. Can you briefly describe your arguments and how do these relate to referrals to the ICC?
Great, thank you for that question, Melissa. And let me say, it is such a pleasure to be on this panel with my co-panelists. I'm so delighted they're here. And I also want to thank Canada, the Kingdom of the Netherlands, the Permanent Mission of Costa Rica to the UN, and the Permanent Mission of Sierra Leone to the UN, and PGA for co-sponsoring. So the central premise of my book is that the veto power, which is found in the UN Charter, exists in the context of a system of international law. It is not over and above and apart from this system of international law. As Richard put it, it is part of the rule of law, and that needs to be applied. So my book looks at the veto against three sets of legal obligations. The first are the protections of jus cogens. So genocide, war crimes, crimes against humanity are protected at this very highest level of law. So to have a veto block the council when at least 9 other states support the resolution being voted on, and that's the number required for it otherwise to pass, even where the resolution is trying to stop or ameliorate the commission of atrocity crimes, genocide, war crimes, crimes against humanity, this appears completely at odds with saying that we have this highest level of protection related to these crimes. My second set of arguments looks at the UN Charter. So the veto is something found within the UN Charter, which requires adherence to international law, respect for human rights, the obligation of good faith, and cooperation in solving matters of a humanitarian character. So we have to ask, are the vetoes being cast in accordance with the remainder of the UN Charter's obligations? Thirdly, we have some treaty obligations, such as the Genocide Convention and the obligation to prevent genocide. We have the Geneva Conventions and their common Article 1, the obligation to ensure respect for convention provisions. So are the vetoes in accordance with these? Relating this to referrals, referrals are put to a vote because council members believe genocide, war crimes, crimes against humanity are occurring. A referral is both a prevention tool. It is designed to tell would-be perpetrators there is jurisdiction over you, and there's a prosecutor's office watching. Referrals are also an accountability tool. They're designed to ensure justice for crimes, and ensuring justice is another way to cut off recurring cycles of violence. So when a referral is under consideration, let's say genocide is suspected and the referral is vetoed, our legal questions would be, is this consistent with saying genocide is prohibited at the very highest level of the law? Is such a veto consistent with the purposes and principles of the UN, which include respect for international law? Now, given there are obligations to prosecute core atrocity crimes, obviously blocking accountability is not respect for international law. And thirdly, is blocking accountability consistent with the obligation to prevent genocide found in Article 1 of the Genocide Convention? The Bosnia v. Serbia case of the International Court of Justice says this is a due diligence obligation for a state to use its best efforts based on its position of influence. Well, is a vetoing state using its best efforts to prevent genocide when it blocks accountability? Obviously not. Now, just to note, I'm not the only one making these arguments. Increasingly, one sees states raising these legality issues, and this is important. States need to go on record that the remainder of the UN Charter matters, as well as other obligations of international law when we look at vetoes.
Thank you so much, Professor Trahan, for outlining your arguments. Now let me turn over to Ambassador Correll. Ambassador, what do you think of Professor Trahan's legal arguments, and how do you think they could be best pursued?
Yes, I'm unmuting myself. Yes, I think it's very important. Can you hear me? Can you hear me? Because I have an
We
indicator
can
here
hear
that,
you, Ambassador. We can
yeah,
hear.
no, all right. But I think it's extremely important. And I must say that I tried myself to convince the permanent members of the Security Council that they should not use the veto power in 2008. And I wrote a letter to the members of the UN making this suggestion. I had not reasoned in the same manner that Professor Trahan reasons. And this is why I found the book extremely interesting. And before I leave the floor, I will post on the chat, in the chat box, a reference to the article that I mentioned, memorial lecture of Professor Hilding Ek, where I discuss Professor Trahan's proposal. And I think it's so important to look carefully at what we suggest here, for the simple reason that this would be a legal argument. My hope in 2008 was to convince that member states and the permanent five should, shall we say, abstain from using the veto just because it wasn't proper. Now, there is an argument that there is a legal obligation not to use the veto in case the Council contemplates addressing a question of genocide, war crimes, crimes against humanity, and so forth. So I think it's really a step forward, and I hope that what is suggested here, that the Security Council, that the General Assembly should ask the International Court of Justice for a legal opinion with respect to Professor Trahan's reasoning. And let me also say, with respect to Justice Goldstone's intervention here, that I have great respect for those who have served in the field addressing questions of a practical nature. If you sit in an office in New York or so forth, this is interesting, but if you are in the field, you actually see all the elements that are there. And therefore, it's so important to listen to the practitioners to understand what this is all about. And I'm an ambassador, yes, but I'm actually a judge from the beginning. I served for 10 years, from 62 to 72, on the bench in my country, Sweden. And I learned a lot during those years. And one important element when we come to criminal law is that the purpose is, of course, to punish those who commit crimes. But the main overriding purpose is to make certain that people do not commit crimes, because they can see what happens if you do. And therefore, if the Security Council just once demonstrated under the ICC statute that they will go after heads of state or people at that level who commit these crimes, this would send a signal around the world that they would be very careful when they are in these positions and see to it that they do not engage in these kind of activities. So this is why I think it's so important that the Security Council actually understands that their role is to prevent crimes. And one of the best and most effective elements to prevent crimes is to use the tools that are there. And in particular, in this case, the tool to ask the prosecutor of the International Criminal Court to address a situation somewhere in the world where these kind of crimes are committed. But I will refer to my lecture that I mentioned here, and I'm typing a message now, and I am pasting it, and I am then hoping that it comes out, yes, in the chat box, so you can see the link there. So instead of speaking too much now, I refer to this address. Thank you.
Thank you so much, Ambassador. And I will now turn to Justice Goldstone, and I'll ask the same question of you, Justice Goldstone. What do you think of Professor Trahan's legal arguments, and how do you think they could be best pursued?
Right. Well, thank you for the important question. Professor Trahan's legal arguments, in my view, are compelling, if not unassailable. They are grounded firmly on the recognition that the Charter of the United Nations, although regarded as a super treaty, does not in any way supersede international law, and more particularly international criminal law. The Genocide Convention and the Geneva Conventions, as Professor Trahan has said, together with the compulsory norms of customary international law, obviously remain of full force and effect and bind all states. So the Genocide Convention, for example, obliges all states to prevent and punish the crime of genocide. And that is now a customary international law, and it's a binding norm on every state, on every member of the United Nations. Similarly, the Geneva Conventions oblige all states to prevent and punish serious war crimes. Those are norms that bind all members of the United Nations, and this clearly includes the permanent members of the Security Council. And that really goes to the heart of Professor Trahan's argument. The veto must surely have to be exercised in accordance with those and other binding norms of international law. It is from that premise that Professor Trahan's legal arguments flow. It is clearly time, I would suggest, to go from the legal arguments to the political arena. It's clearly time for the General Assembly to call out governments that act in violation of those international laws. And I'm strongly in favor of supporting, as has been suggested a few minutes ago by Ambassador Collateral, that the General Assembly might also approach the International Court of Justice for an advisory opinion on the unlawful use of the veto. And by unlawful use of the veto, I would also include the unlawful threat of the use of a veto. Unfortunately, we see too frequently that the mere threat of a veto closes the mouths of the members of the Security Council, including the other permanent members. The threat of the veto effectively, in many cases, stops a resolution from reaching the table of the Security Council. So it's the threat and use of the veto in these unlawful circumstances that should now obtain the full attention of the whole General Assembly of the United Nations.
Thank you so much, Justice Goldstone. Professor Trahan, what are some ideas for operationalizing the ideas in your book?
Great, thank you, Melissa. Just perhaps to expand a little bit on what Justice Goldstone just said, so we have vetoes, we have veto threats, but I also want to say we have a third situation where resolutions are just not even put to the council. So no one has drafted a referral of the situation in Myanmar, that be referred to the ICC. And it's because of the sense that the veto seems to be treated as it's above all law, that the rest of the council realizes, well, it's hardly worth drafting because we know this will be vetoed, so we know it won't happen. So we won't even discuss it. We won't even put it. And then the world doesn't really know what is happening. Why is there no accountability for crimes internal to Myanmar? Why does the ICC have to try to find crimes that cross the border so that one element of the crime is in an ICC state party? And it is all because of the veto. Why won't there be accountability related to crimes against the Uyghurs? Why do we know there absolutely will be no referral? It is because of the veto. So it's really also this third situation that some of our more important referrals do not even get drafted. And it is simply because we have not had these difficult questions asked, because for 20 years we pursued voluntary veto restraint. And that is important. It's the ACT Code of Conduct, the French-Mexican initiative. It first surfaced in 2001 in the ICIS's report, which is why I'm saying we've had this for 20 years. Permanent members, please don't use your veto in the face of atrocity crimes. And UK and France have joined. But when we have only UK and France joining, we do not have veto restraint. But in response to your question, Melissa, I have had certain ideas. They may not be the only way. I welcome the panelists, I welcome the audience, particularly states, to think of creative ways for raising this. My ideas are, first, states need to raise these issues. So they should go on record. Canada recently did this at the May R2P debate and said the veto needs to be used in line with international law and the UN Charter. It is that simple. These simple statements, that is a very powerful statement by Ambassador Ray. Other states have been raising these issues, such as abuse of the veto power, and they should continue to raise these questions, go on record and create this record. Second, states might consider a resolution in the General Assembly addressing some of these existing legal limits to the law. And I emphasize existing because my arguments are not the law as we would like it to be, but I ground them on very old documents by now, the UN Charter, the Genocide Convention, the 1949 Geneva Conventions, as they are interpreted by the ICJ in the Bosnia-Serbia case, Nicaragua and wall cases, etc. And there are a lot of ICJ rulings that the Security Council powers are not unlimited. Thirdly, states could consider requesting an advisory opinion. I have thought of this way to pose it. Does existing international law contain limitations on the use of the veto power by permanent members of the UN Security Council in situations where there is ongoing genocide, crimes against humanity, and or war crimes, or these crimes are at serious risk? That is my proposed formulation. And quite simply, if we want to operationalize R2P, to be able to use it, this issue needs to be tackled. And if the international community is serious about never again, it really needs to tackle this issue. I'll stop here. Thank you.
Thank you so much, Professor Trahan, for outlining so clearly some of the ideas to operationalize your arguments in your book. I would like to now turn to Ambassador Correll and ask, what are some of the other collateral costs to a lack of accountability in a particular situation when there is no attempt to deter atrocity crimes? Please, Ambassador Correll.
This is very serious. This is very serious. And I mean, it points to the fact that the Council is simply not up to standards here. And if we look at the UN Charter, we should never forget that it is a heritage from a generation that had experienced 2 world wars. And the Geneva Conventions that was mentioned by Professor Trahan are extremely important here. And therefore, I find her arguments, the 3 elements that she, shall we say, brings forward in her book, are so important. And this means that the Council should be very careful, because if they do not act on this, they send a signal to the world that doesn't matter. You can do whatever you want. We will not come after you. And I think it's very important that you do not bow in the Council to the threat of a veto. It is better to propose, make a resolution proposal in the Council, have it properly discussed, and then have the vote. And then the country or the state that uses the veto, in spite of that, there would be a majority otherwise for a resolution, goes down in history for actually accepting that the crimes against humanity, war crimes, etc., are being committed without the Council taking action. And I think that the lesson learned from the 90s was that here the Council thought that it was necessary to establish the Yugoslav and the Rwanda tribunals, not only to bring to justice those who were guilty of these crimes, who were the suspects, and bring them to justice, but also that you send a signal here to the future that this is what's going to happen. And that is why when the Rome Statute came into force, I was very hopeful that this would really generate a new situation where the Council didn't have to establish with all the bits and pieces that you have to put together a new court, but simply to turn to the prosecutor of the International Criminal Court and ask the prosecutor to address the situation somewhere in the world. So I think it's very damaging if the council is not up to standards here. And I mean, it's also reflects on the council when they behave as they did, for example, when the UK and the US attacked Iraq back in 2003 in violence of the UN Charter, and when Russian Federation attacked Georgia in 2008 and then Ukraine in 2014, permanent members of the Security Council violating the very law that they are set to supervise, the UN Charter. So the elements here in Professor Trahan's book are so important to bring into the discussion in the Security Council. Have the Council consider these legal arguments and come to the conclusion that, yes, we have to intervene here. Thank you.
Thank you so much, Ambassador Correll. And Justice Goldstone, I will ask you the same. What are some of the other collateral costs to a lack of accountability in a particular situation when there is no attempt to deter atrocity crimes?
Well, there are a number of collateral costs of failing to implement justice in the face of atrocity crimes. The first I would refer to is cycles of violence. It was certainly the experience in Rwanda in particular that over decades there were cycles of violence that led to acts that in the end amounted to genocide. But in the former Yugoslavia too, there were cycles of violence. And the implementation of the justice system through the Rwanda Tribunal and the Yugoslavia Tribunal has certainly, and particularly in the case of Rwanda, stopped these cycles of violence. The same applies in many other regions around the world. The second collateral cost is the destabilization of whole regions. The effect of the Rwanda genocide of 1964 destabilized the whole of the Great Lakes region of Central Africa. Huge refugee flows. Throughout the world, international crimes have destabilized and caused refugee flows. Since 2000, an increase of 80% of the flows of refugees. Then that too leads to huge additional calls for humanitarian assistance. The cost for the global community is just huge. And the calls by the United Nations for funding to deal with the humanitarian disasters facing the world at the moment simply are not, and indeed may not be able to be met. All of this detracts from efforts to counter global warming, climate change, and pandemics. These are all costly issues before the international community, and in particular the United Nations. The highest cost, of course, is impunity for war criminals and diminished respect for international criminal law. The fact that the United Nations, because of the Russian veto, turned its back on the terrible crimes in Syria has meant effective impunity for the war criminals in that country responsible for these crimes. The global community is the loser, and in particular, the many millions of innocent victims, children, women, and men. Thank you.
Thank you so much, Justice Goldstone. Professor Trahan, I will ask you to sort of answer the same question about the collateral costs to a lack of accountability, where there is no attempt to deter atrocity crimes.
Thank you, Melissa. Yes, I think my answer is much the same as Justice Goldstone, that a lack of accountability means recurring cycles of violence, which means IDP and refugee flows, and then the need for massive humanitarian assistance. Failure to cut off cycles of violence means that the international community's attention is not dealing with climate change and pandemics and other neglected priorities such as development, because it's a triage approach, because the crimes have not been addressed head on. Most importantly, it is a failure for the victims. The justice needs to be ensured. The victims need to be our central focus. Vetoes that block accountability are a complete abdication of responsibility owed to the victims, and they are a failure to respect fundamental principles under international law.
Thank you so much, Professor Trahan. We will now move to the Q&A section. If I welcome all questions or comments. If you have any questions or comments, please raise your hand and try to speak slowly and clearly so that we all hear very well. I don't know if there are any questions, comments. I see my Secretary General, David Donat-Catin. Please, you have the floor.
Thank you, Melissa, and above all, thanks to the distinguished speakers that preceded me. I hope that the audio comes clear here from the Assembly of State Parties. We are in the cafeteria of the Assembly. I just wanted to make a comment that relates to the situation in Afghanistan, where really the collateral cost has been corruption, grand corruption. Because I think the lesson to be learned from the total impunity, especially of the leaders of the Northern Alliance, who started to rule Afghanistan after that it was liberated from the totalitarian regime of the Taliban, is that they were not tried for the atrocities that they had committed in the course of the war and after the war. President Karzai, at the time, after you remember the Bonn Agreement, the rule of law was very important there as an element to fight impunity. The Security Council issued a resolution establishing a United Nations peacekeeping operation, giving an invitation to NATO to use the necessary force to stabilize and so on. But the rule of law was an element there for the rebuilding of the justice system and so on. And in all these process, President Karzai, it was February 2003, he realized that the domestic courts and prosecutors were not able or willing or both to take on the generals, the leaders of the Northern Alliance mass atrocity crimes, as well as also some of the Taliban crimes and some of the other atrocities that had been going on. And that's why he ratified the Rome Statute, issuing a press statement saying, notwithstanding the negative advice from our major strategic ally, the United States, we sovereignly decide to affirm the rule of law and join the Rome Statute to fight impunity. But nothing happened after that. We took upon ourselves in PGA to look back at what happened during those years, nothing. And the first meeting that the first prosecutor had with Afghan leaders was during the PGA's organized Consultative Assembly of Parliamentarians on the ICC and the rule of law in Santo Domingo, November 2008. And we know the story of the last years. So the reality was that those leaders were under total impunity. And then when they become also political leaders in the new Afghanistan, what was the difference for them to become corrupted, to take in their pockets the millions of the dollars that they should have spent for the welfare and the well-being of the Afghan people? Then when the war restarted, the soldiers wouldn't want to die for them, and they let the power to the Taliban. So you see that corruption is the result of impunity for mass atrocity crimes. When I hear my NGO colleagues at the UN in other forums shouting against corruption, I always say, look at the roots of corruption. And I think this is one of the collateral damages, and the same applies when the Security Council is vetoing referrals to the ICC, in my own view.
Thank you so much, David. I would now turn the floor to Ambassador Correll.
Thank you. First of all, a point of order here. If you want to raise your hand, you have to go down and down to the right in the picture where you have assigned reactions. If you press that button, you will see a hand. So if you ask for the floor, you have to use that button, otherwise the moderator won't see you. Let me say that what was just said about corruption is so true. Corruption is one of the worst enemies of the rule of law. And Kofi Annan was very, very much aware of this. And when we signed the treaty on corruption in Mérida in Mexico in December 2003, he added that element to the global compact that he had announced earlier. So there are now the principles, the 10 principles in the global compact, but the business community should contribute. But this not to punish corruption is also a problem that undermines the rule of law in a state. So therefore, one has to be consequent here and really do the best one can to come to justice with these people. And I think that the situation in Afghanistan demonstrates that it is not possible to establish peace and security just by bringing in military. You have to start building up the rule of law from the beginning. And that's a very, very difficult situation in the country where there's no such tradition. But here again, the Security Council can contribute by observing the rule of law themselves. Thank you.
Thank you so much, Ambassador Correll. I wonder if there are any other questions, comments from participants. I don't know if the panelists want to add a few words to what have already been said.
Well, certainly, I would say a few words about grand corruption, about kleptocracy that has been referred to by Ambassador Correll. It's really one of the reasons that I've been very much involved with Judge Mark Wolf of the federal court in Boston in the United States, and we've been working very hard to get support for an international anti-corruption court. One of the motivating factors is that such a court will be able to freeze ill-gotten gains, and we're talking here about trillions of US dollars, not billions, but trillions. And I know that the idea certainly has the support of many leaders around the world, including Ambassador Correll and including the Canadian government and the Canadian opposition for that matter. But again, it's the threat of being able to freeze and repatriate at an appropriate time ill-gotten gains from overseas banks. Because one thing that these corruptors have in common is they don't keep the ill-gotten gains at home. They want them safely put into some safe haven, whether it's in Europe or one of the small island states. So we're talking here about corruption and about crime at a huge level, whether it's genocide, Geneva Convention, war crimes, even aggression, which is now within the jurisdiction of the International Criminal Court, and grand corruption. They all have to be dealt with by the law, and certainly the people must know, leaders must know, that they are bound by, like everybody else, by the rule of law.
Thank you so much, Justice Goldstone. And as Professor Trahan put in the chat, I would also like to thank again Canada, the Kingdom of the Netherlands, the permanent missions of Costa Rica, and the permanent mission of Sierra Leone to the UN for their support to this event. This is truly an essential topic, and with the victims in mind, we need to do something about the Security Council vetoes or threats of vetoes in face of such atrocities. If there are no more questions, no more comments, Professor Trahan, I think you would like to say something.
Yeah, thank you. Yeah, just as I think we are wrapping up, just to make it very, very clear the cost of the veto. So in my book, I have this very, very dispiriting chronology about the crimes in Syria and what all of the crimes that were occurring and what was known about the death tolls on the date of the 16 Syria vetoes. Today, we're really focused only on the veto of the referral, but massive crimes by that time. I think it was crimes on both sides, but of course it starts more off with regime crimes. And what a veto says is perpetrators, there's no accountability. That's what it communicates. And then in Myanmar, when we early on have one actual veto, 2007, it conveys to would-be perpetrators, you have a protector on the council, that you're not going to face an ICC referral. And if crimes are being perpetrated within the territory of a permanent member, perpetrators also know that they won't face ICC referral. This is not the rule of law at work. The rule of law cannot apply so selectively. We have to push back, fight against this, and fight towards achieving universal ratification of the Rome Statute, but challenge the use of something that is created within the UN Charter to block accountability, that is being used to be a block accountability. This cannot be a proper reading of the UN Charter to condemn individuals. And sometimes I'll just say one more thing, we have a very direct linkage between the veto and fatalities on the ground. And I trace it most directly related to chemical weapons. That when we have the vetoes of the joint investigative mechanism that was attributing responsibility to those using chemical weapons, we have an increase in chemical weapons attacks. When it had previously been created, these mechanisms, there had been a decrease. So on that veto, we see a pretty direct correlation. So I think we have to conclude that the veto is costing lives on the ground. It's not always possible to make such a direct correlation, but when you have no referral of the situation in Syria, you will not have a referral of the situation in Myanmar, and you will not have a referral related to the crimes against the Uyghurs. It is very clear that the veto is costing lives.
Thank you so much, Professor Trahan. I will now hand the floor to Ambassador Correll before David. Ambassador Correll, please, the floor is yours.
Thank you very much. I cannot stress enough how important the comments by Professor Trahan was here. It's extremely important that the Council actually demonstrates to the world that they are following the rule of law. I refer again to my article, which the link is in the chat box. So please don't miss that one, because in that there is a reference to 2 additional articles that Professor Trahan has written, which will be very important when they discuss in the General Assembly the question whether one should ask the International Criminal Court for an advisory opinion. So look at those articles as well, not only the book, but those articles as well. References in my article. Finally, I would like to mention following. We are discussing vetoes, but we haven't really talked about how much the veto is used. And here students at Uppsala University here in Sweden have analyzed the use of the veto from 1991, when the Soviet Union became the Russian Federation. And they updated their analysis in October, a month ago. And they count that during this period, 59 vetoes were cast, none by the United Kingdom, none by France, 15 by China, 27 by the Russian Federation, and 17 by the United States. Now, they found that 57 of those were illegitimate. This is a different concept from what Professor Trahan is using. Illegitimate, it means that they are just protecting friends around the world, those who use the veto, but it is not connected to the very serious crimes that Professor Trahan discusses in her book, and this is what we are focusing on now. But still, it is important to realize that 2 of the permanent members have not used their veto during this period. And there are also efforts mentioned in Professor Trahan's book by states asking the permanent members of not using the veto. This is a different system from what Professor Trahan suggests, but this can also be used in parallel with asking the International Criminal Tribunal in The Hague for an advisory opinion on Professor Trahan's reasoning. And I think that this should be done. It's so important. I cannot stress this enough. It is so important that the Council bows to the law and demonstrates to the world that rule of law is a precondition for international peace and security. Thank you.
Thank you so much, Ambassador. Please, David.
Thank you very much. And once again, apologies for the background noise. I just wanted to ask a question to Professor Trahan, who is also the prominent chairperson of the American branch of the International Law Association working group on the ICC. We heard the other day a very, very positive statement by the US Undersecretary for Civilian Security, Democracy and Human Rights, here broadcasted from Washington at the ASP, really an unprecedented, unreserved expression of support for the mandate of the Rome Statute. So my question, and today, well, tomorrow and after tomorrow, we are witnessing this Summit for Democracy that President Biden has put together in Washington, DC to celebrate International Human Rights Day. These are very eloquent signs of a new policy. So my question to you is, what do you think the US could be willing to do in the next future to be more based on law and less based on power politics in the council and outside the council? And if there are signs in your view that things could progress, what can the ILA and other organizations from scholars, the American Bar Association, and many others, including Parliamentarians for Global Action, US members, what can we do together to sort of build on this sort of avenue for change that, at least if you listen to the speech of the Undersecretary, you would say this is a state party supporting the Rome Statute mandate?
Thanks, David. I guess we're on another topic, but I'm always happy to discuss.
Well, it has an impact. Sorry, Jennifer. It is really about also, because what Ambassador Correll said before, he said, these resolutions have been criticized because of illegitimacy, because of political reasons, protecting your clients. What you propose is to use the law, the hard law. They are illegal resolutions. What I am saying to you is there a way for international law, not only supporting the ICC mandate, but also international law as such, to be brought back as one of the main blueprints for US foreign policy, which unfortunately, I must say, in these 20 years of global war on terror or international counterterrorism, let's be honest, international law was maybe the last of the priorities.
David, I think I will simply say that for some in America, we exhale a great sigh of relief when a administration comes in that I think in large part believes in the rule of law. And it takes us out of a very different 4 years that we were facing in the United States. And, you know, it's 20 years since 9/11, and I think there should be some study, some reflection on the whole US response to 9/11, which also ushered in elasticity in some of what would be our legal obligations. So I think we're delighted that the US can be more supportive to the ICC, and certainly coming out of a period when the US was the least supportive, personally attacking the prosecutor and Fakisa Mochotoku, freezing assets, travel bans. So we're very relieved not to be in that time period, or I personally am. And we're optimistic that the US can be much more supportive towards the International Criminal Court. So I'll leave it there. Thanks.
Thank you so much, Professor Trahan. I'm wondering if there are any more questions, any more comments. If there are none, then I will make some concluding remarks. We have arrived at the conclusion of this meeting, and I would like to say that on behalf of Parliamentarians for Global Action, Canada, the Kingdom of the Netherlands, the Permanent Mission of Costa Rica to the United Nations, and the Permanent Mission of Sierra Leone to the United Nations, I sincerely thank you for joining us today for this expert conversation on legal limits to the use or threat of use of the veto in the face of genocide, crimes against humanity, and war crimes. I seize this opportunity to reiterate our heartfelt thanks and sincere appreciation to the distinguished panelists for shedding light on this topic of fundamental importance, especially when we continue witnessing violence and severe human rights violations in many parts of the world. Of course, we look forward to continue working together, and stay safe and have a a wonderful day. Thank you very much. Thank you all for participating.
Thank you.